It is day 17 of the Alec Murdaugh murder trial, and we are continuing our trial analysis with defense lawyer Carl B. Grant. Carl, Maggie Murdaugh's sister just getting off the stand. She is the first family member on Maggie's side to testify. When we heard some, I guess, groundbreaking testimony, if you would describe it like that,
I would say so,
Judy,
absolutely.
explaining what she thought of Maggie and Alec's relationship. And I want to start off with sound from her sister explaining what she thought was odd following the murder of her sister and nephew, what Alec Murdaugh had to say.
And what was your understanding of Maggie's intent or what they were going to do that night?
I was under the impression they were going over to Alameda to visit his parents.
And that's why Alec wanted Maggie to come home?
Correct.
And that was from your conversation with her?
Yes.
She called you to let you know that that's what Alec had called her about?
Yes.
Had to say, and we'll get to the other ones in a moment, but when you listen to her testifying, she talked about some of the things that she thought was odd coming from Alec leading up to the murder and after the murder. What do you take of that testimony, and how is the prosecution and defense going to use that?
Sure, because naturally the argument is going to be, if you didn't lure her to come there, why did she come there? And if she came there to go visit your parents, clearly we know the tragedy that occurred where she couldn't go. But why is it that you never did take her with her? Yet you did mean that you went to visit your mom, so why didn't you take your wife with you? Because that's the purpose of calling her to come in the first place.
And obviously it's very compelling to have Maggie Murdaugh, her sister, testifying for the state in this case. She also talked about something that she thought was odd regarding what Alec Murdaugh had to say, what his top priority was after the murders. That was some critical evidence or testimony today as well. Let's take a listen to that.
And then later I asked him, I said, Alec, do you have any idea who's done this? I said, we have got to find out who could do this. And he said that he did not know who it was, but he felt like whoever did it had thought about it for a really long time.
Whoever had done it had thought about it for a really long time. Does that strike you as odd?
I just didn't know what that meant.
She said she didn't know what that meant. She also said that he said on more than one occasion, I believe was her testimony, that it was his #1 priority to clear Paul's name.
Right.
And she thought that was strange. She said because her #1 priority was to figure out who was responsible for killing them.
Sure. And of course her comments, they have to be taken in context. My sister is dead, and you're focusing on clearing your son's name. What about finding the killer of my son? Again, this is a circumstantial evidence case, and in criminal law, that's the most difficult case to prove and to establish beyond a reasonable doubt. But that's one of the connections that they're trying to make. What was going on in Alec Murdaugh's mind? Why did he make these strange and unusual comments? Why did he not take his wife? All of these things that the common person would have done, and logic says should have been done, but he did not do.
And before the court broke today, Maggie Murdaugh's sister talked about how she thought things, you know, maybe people were attacking the family per se, up until September of 2021, which we now know is the time of the possible suicide attempt by Alec Murdaugh and his cousin Eddie. And now there's a back and forth between the prosecution and defense on whether or not that certain evidence would be allowed as testimony. And now Newman has to decide that tomorrow.
Right.
So why is there a conversation on whether or not that evidence is admissible?
Sure, because the defense is arguing, how can you say you're using it for motive for something that has already occurred? How can I use the incident that occurred on the side of the road in September for a motive for a crime that you allege that I committed in July? So that's the logical argument that they're making. So that's what the judge is going to have to decide once he balances the rules and determine what, #1, does it fit in 404B, that rule that talks about prior instances of conduct, uncharged misconduct, those type things, and when you can and cannot use them, then you balance that against that other rule they keep talking about, 403, whether or not it's more prejudicial than probative. When you put all of that in the mix, the judge has to make the decision, and then once the decision is made, the lawyers have to abide by it.
Carl, I'm so interested in your insight about an emotional element of the testimony that we heard today. At one point, Jim Griffin got emotional. You know, I'm suspect, you know. I mean, he does know the family, so I'm willing to grant him that. But I know that so much in these trials is orchestrated for the benefit of the jury as well. So we'll see how it all plays out. But it's not surprising that he might, because he is close to the family, and her sister looks so much like Maggie.
She does.
My goodness.
Yeah, she does. I've been in one trial so far where I've seen lawyers get very, very emotional to the point of a lawyer having to make a comment to the judge as how he's going to handle that, as far as whether to declare a mistrial.
Wow.
And the judge said, well, I was looking at him. I didn't see him cry. Move on. So that's the way that was handled.
Okay.
Yeah. And there was also a point from testimony from Dale Davis, that's the witness who maintained the dog kennels. He testified that he had never seen any weapons inside of the dog kennels, but he did explain that the Murdaughs kept weapons all around that property, including laying out on their ATVs and other places around the property. What was the significance of that testimony?
I think that's very important. Regardless of how the defense has argued numerous times now that there were guns all over this place. It was just guns were ubiquitous all over the place, here, there, and everywhere, in the trucks, not in, I mean, in the dog kennel, all over. But on this one particular day, the salient point is, where were the guns on this day? And the dog kennel guy said, on that particular day, June 7th, I didn't see any guns anywhere on the property.
Wow. And you know what? Some of the most compelling, if you want to say, testimony in terms of just textbook testimony on the stand. My gosh, the forensic pathologist, Dr. Reimer, was on the stand. Dick Harpootlian tried to challenge her testimony in so many different ways, but she did not bend, she did not break. She pushed back, in fact, and set the record straight with him at one point, saying, we can disagree, but the truth remains the same, something along those lines. I mean, was that really textbook in terms of how you want your witness for the prosecution in this case to perform?
Yes, and it's really hard to cross-examine someone who's a forensic pathologist who has done 5,000 plus autopsies. I think she knows what she's doing. Now, there is a strategy, though, in all of that. I think what Mr. Harpootlian was doing, and he's certainly a very skilled and knowledgeable trial lawyer, he was probably trying to use the strategy of establishing whether or not there was two shooters in this case, all right, to counter the prosecution's theory that one and only one man committed this crime. So I think what he was getting to was trying to
he tried to.
There were two shooters.
She didn't give him much of an opening to pursue it, but that's, I can see your point on where he was trying to pursue that avenue of questioning. Wow.
But the long cross-examination, the direct examination of the pathologist, that would not be advisable for this reason. Number one, you don't want these graphic pictures in front of the jury all of that time. Now, again, I'm not trying to advise Mr. Harpootlian, of all people. He and I have been friends and we've tried cases together. But I can tell you this. If I were cross-examining that pathologist, the first thing I want to do is be short and to the point and get these graphic pictures from the eyes of that jury as fast as I can. Clearly, they'll have them in the deliberation room, but they won't have them on that stand, staring them in the face as I'm examining her on cross.
Yeah. Excellent insight.
And before we go, one more question. The prosecution will most likely rest tomorrow. At that point, where does the defense go from here? What steps will they take? What possible motions will they make?
Sure. Once the once the prosecution, I should say, rests this case, the next thing the defense is going to do is make what we call a motion for a directed verdict. In other words, we're asking the judge at that time to find the defendant not guilty as a matter of law for the absolute failure of the prosecution's evidence. Essentially, there's no evidence on each necessary element of the crime to prove that the defendant committed the crime. Those motions, I'll have to say, are normally denied, okay? Because the argument by the defense counsel normally really doesn't go to the strength of the case, but the existence. And what the trial judge must do at that point, he must look at the evidence in the light most favorable to the prosecution in ruling on that evidence. And when you look at the light most favorable to the prosecution with all that they presented, now over 60 witnesses and 500 plus exhibits, I think he'll find that there's probably enough for the case to continue to go forward to the jury.
Excellent insight as always. Trial attorney Carl B. Grant, and of course the big question, will Alec Murdaugh take the stand? We'll have analysis right here for you on WYS News 10.